Shalom, my name is Michael Decker, and I'm a lawyer within the law offices of Cohen Decker Pex and Brosh. Today I wanted to discuss the legal developments as it relates to the legalization of status of a foreign spouse that is in a romantic partnership with an Israeli spouse, either married or non-married. First of all, there are basically two main laws or sections of laws that deal with this issue. The main law is the law of return. Section 4AA to the law of return basically states that a spouse, a foreign spouse, a non-Jewish foreign spouse of a Jew is eligible to automatic citizenship according to the law of return. And in fact, in the beginning of the state of Israel, when a Jewish Israeli citizen was married to a foreigner that wasn't a citizen and was not Jewish, this foreign citizen would get automatic citizenship according to the law of return, including absorption rights and everything. This changed in the 1990s with the big Russian immigration that came in, because after the Russian immigration, the amount of applications for the legalization of status for foreign partners of Israelis, even when the Israelis were Jews, grew significantly. And the Interior Ministry did not like this. And they basically stopped applying Section 4AA to the law of return. And they decided to apply Section 7 to the law of citizenship instead, which also applies on the legalization of status of a foreign spouse which is married to an Israeli, whether the Israeli is Jewish or not Jewish. However, the Interior Ministry applied Section 7 to the law of citizenship in a very stingy way. So basically, they decided that any foreign spouse of an Israeli, whether he's here in Israel with his Israeli spouse, and whether they have children even here in Israel, or whether he's abroad, first needs to leave the country and be abroad, and needs to be invited back into Israel somehow, through a policy that didn't even exist yet by the Interior Ministry. So there was a large group of couples that this situation applied on them, and they all went to the Supreme Court in the 1990s, and with a petition called the Stamka petition. Justice Cheshin at the time basically gave a long verdict, and he accepted the petition, and he decided that all foreign spouses of Israelis that are here in Israel do not need to leave the country, because that wouldn't make sense. Because if they leave the country, how can the Interior Ministry determine the authenticity of their relationship? In addition, Justice Cheshin more or less wrote the whole policy regarding the gradual process of the different visas the foreign spouse receives, the different stages in the process until the foreign spouse is naturalized in Israel as an Israeli. There were other additional legal developments that were developed over the years. Since in Israel, for example, it's not possible to civilly marry, so this policy was developed also to known in public couples. And in addition, not everyone here are citizens, they're also permanent residents, so this policy advanced also to foreign spouses of permanent residents, and also permanent residents can't marry, so this policy was developed even more to known in public couples that are of permanent residents in Israel. And then this policy even developed to same-sex couples, and so on and so forth. So there were many legal developments, and depending on your specific situation, you can feel free to write to us or contact us with your particular legal situation, and we'll be happy to answer you and to assist you in any way possible. Thank you very much for your time.